To do is to start with a brief introduction and then look at two of the major problems under the U.S. Patriot Act for companies in the IT industries. The Patriot Act was amended or enacted in 2001. We've tweaked it in 2005, 2006, 2011. We hope that eventually we'll get it down to a manageable size. And it's not a single statute. It's actually a compilation of different provisions that have affected over 60 U.S. statutes. So you can go and read the thing, but it'll say, well, Section A is changed to this, and Section B is changed to that. But most of the impact is in a variety of different aspects of existing U.S. laws. We changed over 20 financial reporting and anti-money laundering regulations, and I'm not talking about those today. New surveillance powers, lots of provisions, and I'm not talking about those. Immigration restrictions, expansion of existing criminal statutes, transportation, particularly of hazardous materials. I'm not going to be touching on those either. We're going to be here until next year for the third annual conference. I am going to be talking about are the sections of the U.S. Patriot Act that have to do with the request for business records. There were two different primary impacts. One is that there are some new methods of getting business records from all of you, or at least they're going to try. But they also expanded existing issues. If you think the U.S. Patriot Act is your only problem, we have a bigger problem. There are lots of ways that the government has to get information which have been strengthened and expanded under the Patriot Act, and I'll be alluding to those. So if we're looking at what we've got to cover today, there really are, well, I told above security when I drafted this speech that we're going to be 3 questions. It expanded to 5. What do foreign entities in the United States, or who are operating here from abroad, or who have tangential relationships to the United States from abroad, how do they become subject to the Patriot Act? That was an issue that I got questioned on a number of times on the boat last night. Like if I buy a copy of Word, am I in deep yogurt? So what information can the federal government take? What can we tell our clients? We know about the gag orders. Can we tell them anything? When can we tell them? How can we tell them? Or can we tell them at all? What defenses do we have? This is a country that still believes in due process, some appearances notwithstanding. And we're going to see what defenses are available in the United States to the government's requests. And finally, for those of you who are operating primarily from countries overseas, what can you do to stop the United States from coming onto your territory to request the information that you may have on your computers someplace else? And I'll be working with Martin on that one as he gives us Canada as an example. So let's start with jurisdiction. How do they get to you? And it's not just enough to have some tangential relationships with the United States. The most common method is a direct presence in the United States. You're here. You've got a subsidiary. You've got an affiliate. You've got a joint venture. You own a piece of some entity that is doing business in the United States. Or you have a branch. Maybe you don't have a corporation. You don't have to have a corporation. Maybe you have an office. You have operations. You might have an employee in the United States representing your interests here in the United States, but without the necessity of a formal corporation. And you could have property. You could have a warehouse. You could have real estate. You could have other assets. You could have inventory in the United States. All of that can give you jurisdiction over a direct basis. But most of you know about that. You have a pretty good idea if you have that kind of a presence here, they can come and get you. It's the other method that you have to worry about, and that is the minimum contacts approach. Do you have sufficient contacts with the United States that the government can say it's constitutionally acceptable to come after you. Are you here regularly? Do you have agents? Do you have distributors? Do you have frequent sales visits? Some of you may remember that the United States exercised extraterritorial jurisdiction over certain Siemens companies in corruption with the Foreign Corrupt Practices Act. They're taking jurisdiction over the Germans, based largely on the frequent presence that those German officers had in the United States. They were here so often they were said to have been doing business in the United States, and jurisdiction was constitutionally acceptable. Marketing activities in the United States, frequent contacts for goods and services. So if you are here frequently, you may want to consider what other defenses that you can take, because there is the possibility of exercise of jurisdiction. Let's say they have jurisdiction. What can you expect? There are two types of requests for data that I want to talk about this morning. There are others that I won't talk about, otherwise we'd be here too long. First of all, national security letters. This is not new. The national security letters have existed since 1986, but they've been expanded by the Patriot Act. They're now in Section 505 of the Patriot Act. These are administrative subpoenas. They are not court subpoenas. They are issued from the FBI, but only in terrorism and espionage investigations. National security letters cannot be used in any other purpose. You can get administrative subpoenas for other purposes, but not the dreaded national security letter. And they can ask for subscriber and transactional information from communications providers, financial institutions, and consumer credit agencies. Note that this is transactional information. They cannot ask for content. Almost across the board, you are protected in terms of content. They can get it with a search warrant under the Fourth Amendment of the Constitution, but they cannot get content by an administrative proceeding. The second is Section 250 of the Patriot Act, which are requests by the FBI for any tangible thing. Books, records, the notes that you took on the back of the napkin last night on the boat, that is requested by a judge. Judge involved, but it's not your normal constitutional judge. It's a judge that is in the Foreign Intelligence Surveillance Court. And they don't tell you what they're doing. They're not required to produce records. They're not required to produce them to anybody except the National Security Administration. So if you want to know what the Foreign Intelligence Surveillance Court is doing, let me know if you find out, because I'm still trying. And but they do have to show reasonable grounds that things are relevant to an authorized investigation. So that's the quick overview. Let's talk about national security letters for a minute. Again, these have to do with transactional data. Content needs a search warrant. They can use the national security letters under 5 different laws, including the Patriot Act. So if you don't follow the Patriot Act, they can still get you some other way. They can get information from wire and electronic service providers. They can get it from financial institutions. And this includes some people that I would not normally consider to be financial institutions. I'm sorry, I love my car dealer. They've sold me some excellent vehicles. I don't consider them to be a financial institution. The Patriot Act does. Travel agencies. Gee, the people that bought your tickets to get you down here could be all of a sudden one of the people subject to a national security letter. Why can they go and get this without a search warrant under the United States laws? Because it's considered to have been information disclosed to a third party and it's lost its constitutional protection. We have some problems with that. We're working on it, but we haven't changed it yet. But notice the usage numbers. There are a lot of national security letters going out. In fact, if you're worried about the Patriot Act, don't worry about Section 250. Worry about the national security letters. Because almost 193,000 national security letters have gone out between 2003 and 2006. 50% of these were against U.S. persons. That means the other 50% were not. So these are things that we worry about. How do you defend yourself against a national security letter? Basically, the FBI agencies issue them, they get sent, they arrive at your doorstep, they present them, they tell you that they want the following information. There's a lot of problems with national security letters in the sense that they've been held unconstitutional in a number of cases. That hasn't stopped the FBI from trying to use them. We have tinkered with some of the requirements in terms of the defenses that you have. They have been held unconstitutional with regard to First Amendment concerns for electronic communication records. So if you're trying to get transmittal data and packet data off of your computers, you probably have a fairly good defense to them taking it. Doesn't mean they won't try and get it, but you probably have a good defense. This does not help our friends in the banking industry, where you've got bank, credit, and consumer data still available. The reason why the electronic communications are protected is because there are First Amendment concerns under our guarantees of free speech. And then they've decided that they're going to clarify some defenses and actually give you something that you can do to oppose a national security letter. If you find yourself being served with a national security letter, you can petition in federal court for an order saying, let's set this thing aside, let's modify it, it's too onerous, it's oppressive, it's unreasonable, it's just otherwise illegal. And there are procedures by which they have to react to that quickly, within a certain number of hours, so that you get an adjudication of whether or not you're going to be subject to the production order within a reasonably short period of time. The FBI also has to tell you what your rights to defenses are. They can't just show up and say, oh, hey, you've got to respond to this thing. They have to tell you how you can oppose it. So if you find yourself being faced with one and you don't get the notice saying, here's what you have to do if you don't like this, stand your ground and insist on a search warrant. There's been a lot of evidence of the FBI misusing national security letters, and Congress continues to worry about it. They're demanding a variety of reports from the Department of Justice. Don't know if it's going to do any good, but at least we haven't rolled over and played dead on the issue. Now that's how you defend against the production order. What can you do about the gag order? Is there a gag order in a national security letter? Guarantee you there will be one. And it makes sense. They're only used in investigations that have to do with terrorism or national security. Of course they're not going to want you to talk about this. It actually makes some sense. So, but in the 2005 and 2006 amendments, they did say, you can still talk to your attorney. We didn't mean to restrict your right to talk to an attorney. And you can also go to court and challenge an order that's unreasonable. If you do it in the first year of the national security letter, the standards for overturning this are incredibly high. Basically, if the FBI or the Attorney General says it's essential for national security, the court's going to say, nah, you got to go with it. The national security letter stays in place. If, however, it's over a year, then the risks evaluation is much lower and you have a much better chance of getting it overturned. In the meantime, for the FBI's perspective, silence is golden. There was a case in the Second Circuit that tweaked some of that and basically said, this is how you're going to have to structure the options to oppose the gag order. The recipient, if there is a gag order, can say to the FBI, I'm not going to comply with this. Are you out of your mind? And the FBI can either sue to keep it or they can drop it. For the most part, they sue to keep it. There have been a few instances, but for the most part, they do sue to keep it. But at least you think that you've had your day in court. So that's gag orders under the national security letters. Let's talk about Section 215, request for data. This is the other leg to the Colossus. Section 215 expanded records that were available under the Foreign Intelligence Surveillance Act. Note that it has to be issued by the director of the FBI or one of his high-level designees. These are not casual orders. It has to be for any tangible thing, and it has to be issued by a magistrate of the Foreign Intelligence Surveillance Court. We have to show not probable cause that we need it, as our Constitution requires, but that it is relevant. Excuse me, what is relevant? Well, they tweaked that in 2005, so it has to be authorized to an authorized investigation, not concerning a U.S. person. We still get to exercise our First Amendment rights, or it protects against international terrorism or clandestine intelligence activities. If it does go against a U.S. person, it can't be within what's protected by the First Amendment. And, as one would expect, it is usually accompanied by a non-disclosure order. So the 215 sections are at a higher level than the national security letters, which are much more easily administered. So what are the other critical differences? The 215 order can get different types of information. It is much more expansive than the NSLs. Broader purposes, more controls, because it's under the FSC, and it's also harder to challenge. But the critical thing, from my perspective, and for you as the recipient, is this. The Section 215 orders, there haven't been that many of them. They are increasing. The Gartner Group has said, meh, there's not a big deal. Look at the number of NSLs in 2006 alone, and over 300,000 of those altogether. So those are the critical differences between the two. Now let me talk a little bit more about what's under the Section 215s, and then we'll get to defenses. How do you challenge a production order? I guess the summary of this slide could really be good luck with that. You can file them. You can file a petition challenging the legal basis. The judge has to appoint, once it goes into the court, the judge has to appoint someone to review it within 24 hours. You get an answer within 72 hours, and the order may be set aside if it doesn't meet the requirements of the Foreign Intelligence Security Act or if it's otherwise unlawful. Which sounds fine, except again, if the government says, this is really important and it's a matter of national security, the chances of it being set aside are about as good as a popsicle in purgatory. It's not going to happen. And we've only had about 6 of them set aside altogether. And in one of those cases, after the FISA order was set aside, the FBI went and asked for the same information under a national security letter. So it's not working. You can also challenge the gag order. And again, I would say, good luck with that. The challenges to those orders are the same as for the production order. And again, we've got 2 orders here. We've got the production order, give me the documents. And you've got the gag order, and don't tell anybody about it. You can tell your attorney, and you can tell the people who have to actually go and make the photocopies. Other than that, you don't tell anybody. If you want to tell anybody else, you have to challenge the gag order. The 2006 amendments made clear that you can tell your attorney, and you don't have to give them the attorney's name. If you have to tell anybody else to go get the documents, you can have to tell them the name of who else is going to have information. You can challenge the gag order if it's not frivolous. The challenge is not frivolous. The gag order could be set aside, but look at the standard. You have to show that there is no reason to believe the disclosure may endanger the national security. Anybody can figure out a reason why something might endanger national security. And it might not endanger national security or interfere with a criminal, counterterrorism, or counterintelligence investigation, interfere with diplomatic relations. or endanger the life or physical safety of any person. If the government can't figure out how to hang its hat on one of theirs, they're not trying hard enough. So, as a matter of fact, and the government certification is dispositive unless there's bad faith. And that is why there have only been 6 of those set aside. So, if we assume that you can challenge a national security letter, then you've got some prospects of success. But it's hard to challenge a gag order in either case. And it's really hard to challenge a Section 215 order. Then the question is, okay, they can come after me in the United States. Haven't done it a lot in the FISA orders, might do it more in the national security letters. And we'll talk later about why they might want to. How do you defend yourself? Well, first of all, if you're in the United States, you have the court system and the procedures I just described. If you're overseas, you've got the danger that the United States is going to do the long arm of the law thing and see if they can get your documents that you hold overseas. They may serve your U.S. subsidiary or your branch or your other U.S. presence. They may go under the minimum contacts analysis that we talked about. If you've got a foreign parent, they can serve you directly overseas by the minimum contacts process under the federal rules of civil procedure. They can serve an officer or an entity if they're in the United States. You have pleasant greetings. Your president shows up for a trade show and you get served with a subpoena to produce documents. Or they can use the mutual legal assistance treaties that the United States has with many of your countries. And if anybody wants to know if their country's on the list, I have it. Now, tax evasion is not included in some of the tax haven jurisdictions, but we're not talking about money laundering today. So, how do you defend against this? And this is where your countries get to step up to the plate. The law of the foreign country involved is going to determine what defenses are available. Your existing country laws on data privacy, international cooperation, international civil procedure, we won't accept that, which international treaties you've subscribed to, and what your own domestic laws on terrorism are. Do you want to cooperate when the United States shows up with a subpoena under the Mutual Legal Aid Treaty? Maybe you do and maybe you don't. Maybe your government says, I'm sorry, not on my territory. We're not doing that. You've got country public policy issues, and including views on the cooperation with the United States. And I'm going to let Martin, who's going to talk about Canada, talk about some of the different views of Canada on how they've been cooperating with the issues, with the United States on those issues. So, where does this leave us? What are you going to be doing and what are the risks of the Patriot Act? Do we have a Colossus? Do we have a Strawman? The Colossus is one that's already existed there. The national security letters have been around for a while. Congress has got their number. They're watching. I don't know if it's going to make a big difference. The risk to you starts with, what's the nature of your U.S. presence? How easily can we get jurisdiction over you? The business of the enterprise. You can't get national security letters for electronic communications, but banks and communications. And remember, I'm just talking about business records here. I'm not talking about the money laundering provisions or the financial controls, which could be an even larger problem. NSLs are the greater risk, except those protected by the Electronic Communications Privacy Act, which is why those are unconstitutional. The impact of the Section 215 orders is small, but growing. So it's out there. There are particularly your foreign country defenses. The U.S. defenses are minimal. I think you're going to be wanting to watch Congress for the next couple of years. There have been a couple of major oversteps by the administration that has Congress as oversight committee looking more carefully at this. But in the meantime, we'll have to assume that the Patriot Act is not just a straw man, that it's really out there, but there are defenses to the reach, particularly in the extraterritorial situations.